Hello, everyone. Welcome back to the class of international marketing. Today, we are going to talk about Chapter 5. It is about legal environments all over the world, but it will be just a panorama, a briefing of all the political situation across the world, some basic knowledge points and principles, some terms that we have to understand. I'm not an expert in legal issues. I'm not a lawyer. Even if you're a lawyer, you just practice in a country or a state, you won't be an expert in international trade. So my best advice is if you work for a company or if you want to run business internationally, it is better if you go over a certain level of scale of business, and you really have to hire an expert to provide you with some legal recommendation. Because every field is different, you have to get a specialized person, specialized expert to help you in specific field. Okay, so business is business, finance is finance, marketing is marketing, legal issue is a legal issue. That is a big deal. Across country territory, it is very, very critical. You understand the rules, you practice legally, you don't want to get in trouble, and at the same time, you want to have the maximum proper self-protection for yourself. Okay, I think let's do the screen sharing. Okay. So on this chapter, we are going to cover, sometimes we call political environments, sometimes we call legal, sometimes we call regulatory environments. And political, strictly speaking, is a little bit different from legal and the regulatory. It has a lot to do even with the stability of the government, political system, and so on. Legal and regulatory, it's another aspect, but it will be a byproduct. It's highly correlated with political structure over there in different countries. The learning objective is we'll have an overview, very, very brief overview of the political environments across the world, get some definition on the political attributes. Then we talk about the legal or law system across the world. Also very, very broad, very high level, superficial level of understanding. Then we talk about some important legal issues in the business. If you're doing international business, but if you do domestic business, it's the same thing. Some of the terms you have to understand: patent, trademark, and licensing, piracy, and so on, trade secrets, all these things. Then we talk about if you have an issue for business issue involved in international trade, what will be the solution for that? There are different solutions you will have. And lastly, just a rough coverage for the regulatory environments in European Union. Just one slide. I can guarantee you it's just an outline. Okay, political environment. Before we talk about legal system, political environment is most important because legal system basically is embedded in the political system, and sometimes, most of the time, it's determined by the political system over there, over a country. Political culture reflects the importance of the government and the legal system. This is the context that your business is going to run in. Political issues includes, then there are some terminologies over there. Sovereignty, that is basically the authority. Political risks will have a touch on different kinds of political risks. Taxation, that's a big deal for it, because you get a revenue, you get a profit, then what you actually earn will be after tax, right? Tax is a big deal, and if you play global game, tax is also important role. There's all kinds of tax avoidance strategy. Tax avoidance, it doesn't necessarily have a very negative meaning. Avoidance, and if you can avoid it legally, that's a kind of business strategy, and a lot of accounting people or the specialized area that's for tax. So some experts really can help company to save a lot of money on taxation by playing a global game. Because tax rates for different countries are different, and the internal transferring of revenue profit and so on. If you do it legally, you really can take advantage of the differentiation in tax rates across different countries. And of course, you have to operate in different countries. So this is a big game for big companies. If you only work for domestic company, if you only work in the US, probably there's very limited leeway you can go. Then the last two will be related to the ownership or operational authority for you. So equity dilution and the risk of being taken, your business being taken. Okay. Expropriation. Okay, sovereignty, that means supreme or independent political authority. Who sets a rule? Okay, sovereignty. Normally, if a country, within a country, the government of that country should have this sovereignty, have the say on everything every policy that is going to rule the country. So for if you get into global markets, if you have a global market integration, for example, last time we talked about the preferential, those preferential agreements across countries, right? So all these trade agreements will affect the sovereignty of the country to some extent. For example, you get into a economic union, okay, economic union with some countries, and you join the club, and you really allow the capital flow, labor flow, or product flow within all these countries. Used to be the case that you can set tariff against the products from other countries, right? But if you are part of the union, then you within the union, you can't really levy taxes to foreign products, and also abide by the rule of the union. You have to set the same tariff against other countries out of the union, and you don't have the authority to set tax by yourself, and you have to allow other citizens from other countries to come into your domestic market to compete for jobs. That really creates a lot of problem. For example, if you are Germany, you really suffer from that. You will see in European Union, you are facing a lot of immigrants. We call immigrants, but they are legal because people can move freely within European Union. Other Eastern from Eastern European countries, a lot of people emigrate to Germany, to those relatively richer countries, to Germany, to France, to Sweden, to Denmark to get a job, compete with or compete with local citizens in those countries. So that creates some kind of social problem. That's why this is one of the reasons that at the very beginning, UK wants to stand out of that game. They are part of European Union, but there are some restrictions. They don't allow people to move freely they allow people to move freely to UK, but they don't, for example, join into the currency game and so on. And that is also the reason some of the countries, they don't want to give up their sovereignty, so they want to stay out of the union, like Switzerland. In international trade, if you join some kind of treaty with some trade agreement with other countries, keep in mind sovereignty might be eroded to some extent because of the commodity flow, because of the united tax policy, because of the united currency, and so on. Political risk. There are a lot of risks associated with political situation, and all these risks will normally have a bad impact on international trade, because political stability is very important for people to run business for a relatively long time. In most of the cases, that is true. And even within one country, but political sovereignty, the ruling party, or situations of extremists, social security, and so on. All these are part of political risks that companies will evaluate before stepping into a new market. So some of the political risks will be social unrest. That's a big deal. War, crime rate is high. That means well, your business face a lot of threats for security issues, right? Robbery, thefts, and so on. Labor cost is decided by the governments. You have minimum wage, no minimum wage, and so on. If there's a strict rule on minimum wage or control for the labor costs, for business, you don't have the autonomy, right? And sometimes there will be an increased labor costs over there if there's a minimum level of labor cost for foreign enterprises. For example, tax discrimination. They tax local business differently from foreign enterprises. Then you don't compete in a fair game. Repatriation restrictions, whether, for example, you can send people into the host country, a target country, and a host country, or you can send them back freely to the home country. Visa issue in and out, and also capital is more relevant. Whether you can wire money in. Wire money in is easy, but you want to wire money out, it gets very difficult, complicated. Then you have to think about it. If I earn money, make a profit in that country, I cannot take out the money, then am I interested in doing the business over there? Corruption, nepotism, international disputes. Two countries involved a lot in international disputes or trade disputes. Then do you want to go to the other country to do business? Because if there's retaliation, you might be the target. Orderly political transfer. Political situation, unrest. The government changes so frequently from one leader to another leader, one party to another party. And if there's orderly political transfer, like the presidential election in the US, every 4 years you have one transition for the government, or at longest 8 years, you have a transition of the government, of the leader, like president, then it's okay. But if the political transfer is unpredicted, and it sometimes it's just a violent transfer, there's that will create a kind of turmoil in the society. That is not good for any business run in that country. Politically motivated violence, or army curfew, and persecution, all these things, you really want to get away from it. Exchange control, tariff barriers, the money cannot be exchanged freely. High tariff for materials or finished goods or components. Changing government pro-business orientation related to government change, right? Social condition, the wealth distribution is not the good. Population density, you have a very populated area, but you have very isolated area, versus like US, you have big cities, but population is scattered all over the country. That just changed the business operation, operating situation. Dependence or importance to a major hostile power, whether the country is dependent on others, too much reliance on others, and that others is not so friendly to your home country. So that will be a big deal. For example, US and Russia always get the very tricky situation. But if you want to do business in third country, that country has got a very good relationship with Russia, too much reliance on Russia, then do you want to invest and do business over there? Because if there is any conflicts between US and Russia, then there will be some retaliation probably going on. So the third party, their business market situation might be influenced by those conflicts. You should think about that. So that's a lot. There's a lot to think about, to know, to understand, especially if you want to do long-term and the big-scale business in a third country. Taxes, taxation. One part of taxation is tariff. We'll talk about that. We talk about preferential trade agreements, right? Tax union, all these things. But the other part is business tax within a country, whether they want to take lots from your profit or not. So those things will have some impact on your intention and interest in working in a target country. So for most of the economic powers, they set duties against others. Like China sets heavy taxation or tariff on a lot of product categories, although they are part of WTO. Okay, but the WTO cannot eliminate tariff completely. Okay. Now, another part of a political risk will be the safety of your asset. If you go to a market, international market, not every country. If you're from US, we talk about self-reference criteria. Don't use the US standard to gauge the standards in another country. In US, the government won't take your business, right? But for some countries, there might be a possibility or a very high likelihood. So there are three ways that your business can be taken by the government in the entire country. Two are very similar. One is expropriation, but they just give a reason, and they'll take your business, but they'll give you a compensation. Compensation will be prompt, effective, and adequate manner. But all these terms are very subjective, right? What do you mean by adequate? By local market level or by true business level? How can you evaluate the business? There are a lot of tricky parts in evaluating a business. So the adequate is really, you can put a big question mark over there. Okay, needs justification, and all these justifications can be very tricky. Then nationalization. So the government can take your business. They say, we just take it, it's expropriation, pay you back money. And they can dispose the business as they like. They can transfer to a local bidder, okay? Or they can, the other way, if they nationalize it, they take it for as a nationalized state business. It's called nationalization. So nationalization is, I would say, it's a special type of expropriation. Take your business and then nationalize it, become a state-owned company. Okay, but they also pay you, give you adequate pay. Okay, another way is, the last way is confiscation. They take it, no compensation, because you might violate a local rule. You conduct illegal business, so the government step in, say, no, you cannot not do business, and I'll take your business away. It's as a penalty. You don't get any compensation. You don't get any money back. So, do you have great exposure to this kind of risks? These three ways of seizure of your business. If yes, really think about that, whether you want to go to that kind of environment to do business. It's really critical. These are direct seizure of your takeaway of your business, but there will be another thing that's indirect. It's kind of latent process, could be, but it's indirect, taking away of your asset, creeping expropriation. So that's it is enough form, in different kinds of forms, but just to limit your business activity or take away your autonomy in running a business. Okay, so one thing we mentioned is about repatriation. Set some constraints on repatriation. Technical assistance fees, so limit some of the fees you put into your company, so your company cannot compete without this kind of support, right? Increase the local contents laws. They want you to increase local contents, local components, spare parts, local productive parts in it, or the local labor. You have to hire local labor, local nationals. Price control. They set the price button or ceiling for your products, then you don't have autonomy to set your own price. And discriminatory treatment, like tariff, non-tariff, or loss of patent and trade protection. All these that just limit your full control of your business, right? And it's a kind of indirect of expropriation. So for your entitlement to the business. Okay, we finish political risk, then we move to another area. It's international law. There are some common practices in the legal field for business. Okay, but I think it is limited. There are some international organizations, at ICJ, International Court of Justice, but the ruling power is limited. more often you will get exposed to, or you will be protected by treaties and agreements, right, and join part of a big union, or these things to get the same ruling for a set of policies. But for the law system, legal system, we have to understand country by country, the legal system is different. But for Western type of legal system, there are only two types. One is mainly two types, but every country you have variation for that. One is called code law or civil law. Basically tells, well, you should do this, you should do that. These are the principles, we should follow that. Okay, so that's one way. The other kind of law is America. It's common law. What is common law? Common law is basically the decision is based with priority on presidential cases. What happened before, and the previous judgment will be used or be referred for the current judgment for similar cases. So this is past judicial decisions will be the rules that we have to follow. Okay, so that's for common law, but civil law, it's different concept. We just say what you should do. There are some principles we should abide by. If your case fit into that kind of situation, you should follow this principle to make your judgment. Past judicial decisions are important, can be a reference point, but won't if it is against current situation, against some of the principles, probably you should think very carefully about your current decision. But the US is very much rely on past judicial decisions. Okay, so some definitions might be different. For example, the company. In US, state can decide, they have policies on deciding what is company, how companies are organized. So across different states, you might have different idea for companies, different concepts or definition for company. But it is more or less united in the states now. But I think some of the states like Louisiana, they get a lot of heritage from French colony. So they still stand alone for some of the legal definitions and so on. But in civil law countries, companies are defined differently. Okay, so that's a basic concept, common law versus civil law, one by principle, one by past presidential cases or past judicial decisions. There's another law system in another region, that's Islamic law. That's generally followed by Middle East countries, Muslim countries. They fall into two parts, like the code law and the common law, code law, civil law versus common law. Quran Holy Book, it's code law. Basically, there are spirits and principles that you have to follow to make judicial decisions, and there will be hadith like common law, a slightly different practices. In the common law, in the Western countries, you follow by previous judicial cases, but in the Islamic world, the common law is more or less followed on life sayings, practices of Muhammad, their prophet. So that's the situation. I'm not an expert on legal issues. I'm not a lawyer, especially for international laws. So these are a very, very brief understanding for the legal system. Again, if you want to get deep into it, there will be whole course on business laws and international laws and so And it could be your lifelong learning. So learning is unlimited. Okay, now we are not experts on laws. You can never be an expert for laws for all the countries, but we just face that kind of relaxed attitude. What should we do? Echo my recommendation. Get expert legal help. Okay, if you do small business, that's okay. If you just do online business on eBay or whatever, sell to another country, that's okay. Just follow eBay's rules. Because eBay, they have a big team of legal support, so they know how to deal with business in different countries properly. Okay, so you just use their platform, follow their rules, you'll be safe. But when you want to run your own business to a large scale, or you want to seriously put money into establish some business in another country, you get serious market entry into another territory, then you should do more. Okay, get legal help. Okay, get experts to help you. Expert in the target country. Experts who knows how to do business between your country and that country. That's how lawyers are making money. Lawyers, they practice, they have their specialized fields. Immigration, you have immigration lawyers, business laws, criminal cases. You resort to a specific group of lawyers, civil case lawyers. Okay, so prevent conflicts. You understand jurisdiction, that what kind of court is ruling the judicial decisions. You have to understand intellectual property. That's a big deal. When we talk about WTO, one part of the General Council is to talk about to deal with intellectual property issues, and that's worldwide issue. Understand how to deal with the licensing and the trade secrets. Avoid some kind of business practice or gray area business practice, or some behavior like bribery and so on. It's inevitable to this kind of thing will happen in developing countries, in some of underdeveloped countries either. Then it's a very sensitive issue. Okay, people are doing this. It doesn't mean that you should do this or you will get protected by doing this. We'll talk about that. Advertising promotion. There are some general practice in advertising and promotion for some countries. Sometimes it will touch the law. So don't use self-reference criteria. Something you can do, you probably cannot do in some other countries. For example, visual presentation for advertising. There are some restrictions in Islamic countries, especially for ladies and so on. Promotion, some of the promotional tools might not be allowed in certain countries, like sweepstakes. If you want to run in Southeastern countries, you'd better conduct to local people, local experts, whether that is allowed, because sweepstakes sometimes are contacts, sometimes are treated as illegal because it's related to the concept of lottery, gaming, whatever. So gambling. So be very careful about that. Okay, jurisdiction. That is courts authority to rule on particular types of issues. So if you're a company, if you're an American company trying to do business in Japan, okay, you have to understand which kind of court, which court has the authority to make decisions on legal disputes. Japanese courts or American courts, okay? Or whatsoever, any rules that you have to follow. So employees should have a sense about that, and This is very important because you want to, if there's any legal disputes, you really want it to be the final decision to be made or evaluation to be made by the authority that is fair and in favor of you. Okay, will have relatively favorable, or bottom line is fair treatment to you. Okay. So jurisdiction, some rules we have to understand. If we are cross countries, normally courts don't deal with individual legal commercial problems between individuals, only between companies or between governments or between company and the government. So if you do business with some individual in the country personally, and you cannot resort to jurisdiction in the courts. So this is a limitation. There are a rank order for how the jurisdiction is to be determined. Come back to the case if you are exporting to Japan. Okay, the jurisdiction, you really, if you're an American company, you really want the jurisdiction to be at U.S. court. U.S. court makes the decision. You go to the U.S. court, okay, to process a legal case. But there's a hierarchy for jurisdiction to determine. First is the clauses in the contract. If specifically in the contract it says, well, jurisdiction is Japanese court, wow, you're in a very, very disadvantaged situation. So to do the self-protection in the first place, try to add some clauses saying jurisdiction, if there's any legal disputes, you come to US court for the legal process. If you haven't specified that, then where the contract is was entered into, when the contract was signed in Japan, go to Japanese court. In America, comes to American court. The provision of the contract were performed. If the contract, most of the implementation execution is done in Japan, then, well, go to Japanese court. If not, then in another way, it comes to US court. So these are the hierarchies. So the best, if you come out to a lawyer, the lawyer always will pay attention to the legal jurisdictional clauses, okay? They'll never forget about it. So if you are not a person really sensitive to these issues, when you sign a contract, you only pay attention to price, delivery, all these terms, you are not experienced, you don't pay too much attention to these legal jurisdiction clauses, you are not fully protected. So this you have to understand. Okay, country to country, the situation respected to laws, people have the awareness of the legal issues are different. And the settlement process are different. In Western countries, we remember we talk about high contest, low contest culture. For low contest culture, people pay more attention, more respect to the legal procedure, legal authority, jurisdiction thing. Okay, they put it in writing, and they hire a lot of lawyers to do it, and lawyers get a lot of jobs from their practices, right? But for some culture, if it's low context, people don't always go to legal resolution. Then people really don't put too much on the legal clauses, the jurisdictional clauses. Like I know China was really lagging behind. Maybe some Eastern cultures like Japan, it's high context society. You don't have to put everything in writing. And well, legal clauses will be a drawback, a shortcoming, need to like really improve. Then lawyers, accordingly, lawyers in those countries, you take fewer responsibilities in these legal issues, right? So number of lawyers will be representation for high context, low context, and how things are solved through the legal process and so on. Okay, very interesting. How to solve disputes, international disputes. This is very important, inevitably, because of the business, international business, how complex it can be, because of the culture conflicts, because of the logistical complexity, and so on. A lot of disputes can arise for international trade. Normally, people solve in three ways, and they're progressive. Conciliation is basically we sit down and we talk, just the business people, okay? You and your counterparts try to solve it friendly and put in writing. This is our agreement for this issue. Then if these should be implemented, executed by this time, okay? This is a resolution. Then we go back and do what we committed to do. But at the same time, in the clause, it will say something if the resolution agreed cannot be executed, then we move to another level, escalated, basically. It is arbitration. Arbitration is between the final court procedure, litigation, and the conciliation. So arbitration normally go to a arbitration institution. There are arbitration institutions for international business. If you're not in business, you are even not aware of that. But there are arbitration organizations, institutions you can resort to. They solve business issues. It's more binding arbitration clauses. So basically, arbitration, it's almost like a court type of thing. You go there, present your case, and they'll sit down and help you to compromise and reach an arbitrational agreement. Okay, but that kind of agreement is getting more and more serious because there will be arbitration institutional authorities over there. The third party, and they are more like power of enforcement for arbitration. But their enforcement is not like court, like the legal system. They can take your property away and so on. So this is just a respectful resolution, a dispute resolution authority that normally business people will go. Okay. And similarly, there will be an agreement for the solution, and there will be like a deadline and the execution process and so on specified. Then you just take the paperwork and go back, supposed to fulfill what you promised to do. But if not, then we have to escalate again. That's the final step, go to the court. It's called a litigation, but normally this is something we avoid to do. Okay, but litigation, we know that we have the jurisdiction, right? Go to Japanese court, you go to Japanese court. But if there's jurisdictional class, just follow what you should do. Okay, but normally people will hesitate to go to litigation for the following reason. First, they just damage your image in business. Like if you want to make friends in the classroom, but somebody is very notoriously known to always have disputes with this one, that one, and so on. Do you want to make friends with him or her? You will be very cautious in the first place, right? So a company always in litigation with other business partners. If you have other choice, normally you will avoid doing business with that guy. Okay, something is wrong, definitely. Fear of unfair treatment in a foreign court. If your jurisdiction is not favorable to you, like I'm doing business with Japanese partner and I have to go to Japanese courts, I will be very hesitant to do that. So if I can solve in conciliation, arbitration, then I'll do it that way. Avoid going to the Japanese court. It's time consuming and costly, no doubt, no doubt. Lawyers are very expensive. Loss of confidentiality. That's another concern because there are a lot of business secrets, something I don't want to make it public, but when you go to court, you have to collect all kinds of evidence. So if not all, at least a part of the confidential information you don't want to release to the public, you have to present to the courts or release to the public. So these are the concerns. Normally people don't go to litigation, so always get a resolution out of the court. Now we move to another important concept, that intellectual property. We have to understand three terms related to it. Patent. Patent normally associated with an invention, technology, and it tells the ownership for that one, and who's got the exclusive right to use it, to sell it, and so on. And then trademark, and a common example is like a brand, a mark, motto, device, or a symbol used to distinguish one thing from another, one product from another. So typical example is a brand. Copyright is a written, recorded, performed, or filmed artistic or creative work. So you have the ownership of that piece of work, picture, movie, advertising, video episode, and so on. How to understand this completely? Here's an example. I used to have a Chihuahua, okay, very lovely puppy, okay. I raised it from day one. So my puppy, I give him my puppy is definitely get a name, and he's so lovely. I want him to grow well, and I just developed a cookie especially for him, and you see he likes the cookie a lot. So when I develop the cookie, especially for my puppy, okay, if I want to commercialize it, I will apply for a patent for it. The patent is for the recipe for the cookie. So you know the patent. Okay. Then I also give a name for the cookie. It's called a mini-me. So mini-me is a trademark I give to the cookie, a name, a motto, a name for some kind of product, like a brand name. Okay. So patent to make the cookie and trademark mini-me for the cookie. Now I want to show my puppy and how healthy he is because of the cookie. I make a picture of me and the dog and show to people. And this is a creative, inventive work. So if you want to use this for any other purpose or for distribution and so on, you have to get my permission because I have the copyright for this photo. So we have the patent, we have trademark, we have the copyright for these kind of photo. So you understand the difference, some of these three terminologies, right? Okay. One important intellectual property is a brand name, a trademark. And trademark, later on we'll talk about brand name. Sometimes we interchangeably use the brand name as the name of the product. For example, clinics. If we talk about clinics, we immediately will know, well, it's a kind of tissue. Okay, so clinics, give me a clinics. People know that you're asking for a face tissue, something like that. And I want to drink Coke. I want to drink Pepsi. What is Coke? What Pepsi? Actually, Coke and Pepsi can be deemed as a brand name, but at the same time, in different contexts, people will know that you refer to a soda drink of Coca-Cola, soda drink for Pepsi, right? So interesting. For intellectual property, this is a very complicated issue. That's why WTO has a special body working on these issues. Okay, the basic rule of thumb is if you want to get intellectual property, if you want to, for example, register for a patent, register for a trademark, you'd better do it in each individual market, in each individual country, because each individual country, they have they independently handle trademark, patent, all these things. Okay, so that's the general rule. Country by country, you should register independently to get full protection in each individual market. But there are different treaties, organizations, their sovereignty, authority can be over multiple countries. It's so complex. So it's better you consult to some local experts on these issues. Okay, normally some lawyers handling this, they are very clear about the protection, registration, and so on. So see how complex the situation is. There are some patent conventions, organizations, they are ruling across different countries, right? And there are some, you see, over 100 countries, right? Paris Convention. There are even some treaties going on. So it's really complex situation. Okay. International patent companies are doing this. This is really old data, but these companies are still active in getting patents, and patents normally their lifespan is about 20 years. So still they hold, if they hold into 2015, they still hold a big chunk of them, especially in high-tech industry and in pharmaceutical industry. There are lots of patents going on. You get a new technology, think about like a smartphone, iPhone. It's just the one piece of product, but there could be hundreds, thousands of patents associated with it. It's cumulative, okay? Some patents are very basic. They are old technology because those patents, those patents haven't expired. So still, that's part of the patent, that when you make the phone, you have to pay for the usage of the technology. That's why companies like Motorola and so on, they're still making a big money because of the patents they have. They are out of smartphone business, almost out of the smartphone business, but still making money because of their patents registered before. So patent normally will last for 20 years, and the different things we have to register patent across countries, different countries handle patent differently, define patents even differently. So we should understand these, and countries are trying to harmonize, standardize the patent definition and so on. Global software, if you're in software business, patent is even more important than other businesses because software is easy to make and copy. It's just a 0-1 number code, right? So you have to register, get protected, and here are the situations for that industry. Okay, 3 related terms we have to understand, but these are not good terms. Mainly you are stepping the toes on those inventors. Violation, infringement for intellectual property, what we call counterfeit, associated counterfeit, or piracy. These are 3 different terms. I give you some examples here. Counterfeit basically make a fake product, nothing. You just copy something, but it's completely fake. You protected, you are the right product. For example, is this panda? No, it's a dog. But you do a lot of makeups, drawings. It's here. Make it to look like panda. If you claim this is a panda, then you're counterfeiting. Okay, so we have fake money, counterfeited money, right? So this is completely illegal. And the second one is associated counterfeit or imitation. I don't claim I'm Olay. I don't claim I'm Puma. I don't claim Adidas. But what I do is get you confused, imitate it, get you confused, and just take advantage of this confusion. Due to my close imitation, I fooled you and you buy my product. I didn't say it is Puma. So to some extent, I'm legally protected, right? It's your choice. You see this logo and it's in your mind, you thought it is Olay, then you buy it, right? But I didn't claim when I sell it, I didn't say it's Olay. So associative counterfeit or imitation, this is a gray area. But a lot of companies are doing this, especially in developing countries. The third one is piracy. That's unauthorized reproduction for something. So I get a formula of Olay, and actually I make Olay product exactly the same as real Olay product. That's piracy. So piracy is a big deal in software industry because software products is either CDs or all these things are an app. It's easy to copy. It's just a 0-1 code. Everything is digital signal. So piracy is a big deal for these kind of products. Piracy and counterfeit for almost every industry category, industry sectors will have timepiece, pharmaceutical products, computer software, clothes, books, softwares, and so on. Softwares, we mentioned that. So intellectual property situation across the world, some countries are highly protected. Some countries are really lagging behind. Most likely, you can see developing country, easy to understand political system, well established, underdeveloped. You can see very clearly. Some other aspects for legal system, antitrust. Antitrust is to combat or deal with some practices that will create unfair competition. So antitrust laws, for example, it will curb or mitigate monopoly in business, like Microsoft, like Facebook, all these companies, high-tech companies, they were sued because of monopoly market. So this is a kind of antitrust movement. Okay. We talk about intellectual property. Someone gets solely ownership on usage, right to use something. But if you really allow somebody else to use it, for example, allow you to use my recipe to make cookies for puppy, I can give you, basically I'm licensing. Okay, you get the license to do it. Or I allow you to make, use my trademark, mini-me, for some other products, associated products, like dog puppy clothes, like other things. Okay, it's called licensing as well. Or I let you to distribute the pictures I have with my lovely puppy. Then I just license you to use the picture. Okay, so licensing happened a lot in business. Like McDonald's always give franchise people to run their restaurant. Basically, they give franchises a special type of licensing, get the right to use the food recipe management system, promotional process, promotional tools, license to use all the technique and facilities for McDonald's type of restaurants. And also we have Starbucks is a big franchise licensor. Okay, you can franchise Starbucks brewing house or Starbucks products. So licensing will, later on we'll specifically talk about different ways of doing licensing and so on. But licensing decisions normally include the following considerations. What asset to be licensed, the patent or the trademark or something else, okay? Or the brand, something like that. How you are going to price it, what kind of return you are looking for, percentage of revenue, you get loyalty, a fixed payment, something like that. The rights granted to some extent. You're only allowed to use the brand name within this territory for this type of products, or you can, the scope is larger, and so on. Trade secret, it is another special thing. It might not be the patent, might not be the trademark, but there's confidential information, knowledge related to the business. For example, some lab information, lab data, and so on, how people are running the experiments in the lab. And these might not be patented, might not be legally protected stuff, but these are confidential to a specific company. And the company may treat it as trade secret. They don't want to release to the public. So they want employees or people to protect it, to keep it classified. So how can you do that? Use confidential contracts, confidentiality clause of contracts with people involved. For example, if you work for some company, you have to sign confidentiality contracts. You can't release information, these certain type of information, knowledge, or data to other people. Or when you leave the company, within 13 years, you cannot do this, you cannot do that. So that's what we call confidentiality contracts. So this is beyond the traditional intellectual property, the three patent, trademark, and copyrights. Okay, so that's beyond that. Okay. Another aspect will be bribery and corruption. That has something to do with the political risks we talk about, right? These are behaviors normally we can see in the business world, but as an American company, you have to understand, first of all, these things might be illegal. Most of the case will be illegal. Although people are doing this, will be illegal in some countries, but the people do this on the table and they don't get punished in some legal system. That's a market situation here, over there. But if you're a US company, you also have to follow US rules. So United States, we have this rule, Foreign Corruption Practice Act. That means, in general, you're a US company, you're not allowed to do this kind of thing, bribery and corruption behavior in third country. Like Walmart, they get into trouble. When they open their stores in Mexico, it is a big scandal. Try to grease the deal because people are corrupted over there. If you want to lease a piece of land, you have to pay bribery to local officers to get the deal, to get them onto the negotiation table and sign the agreement. And eventually it was released to the public, this kind of deal. And Walmart was hammered heavily. They get into deep mud because of the bribery and corruption behavior in Mexico. Okay, but there are some exceptions. We should be very careful about this. Those exceptions will allow you to grease payment to cut red tape. But what will be allowed, what won't be allowed, be very sensitive. Conduct to the legal experts. But I would first respect the first act. Try to do clean business in another country if you are a US company, and be aware there are some exceptional situations, but don't expect too much on that, and just to go to legal support for that. Get experts to get real accurate clarification for the situation. In an international business world, some companies say they get into trouble for this. As far as I know, these are the correct statistics. 10% of government spending contracts transactions are used to bribe, as bribery, kickbacks, and all these under-table payment. Big companies like Rio Tinto, they are from they are from Australia. This is one of the biggest, probably top three. Excuse me, oil and iron and ore material supply in the world. Excuse me. And when they and who's the biggest buyer for them? It's China, and China is the biggest steel manufacturer in the world. They use a lot of mineral and ores, and they import from Rio Tinto a lot. So it's a kind of interesting situation. One wants to sell, of course, you want to raise the price, right? One is the largest buyer. They always want to control the cost, but they always negotiate and get the agreed amount. So Rio Tinto really want to know the bottom line price for Chinese buyers, and you never know because Chinese buyers, they allied and they organized together to negotiate for a big discount deal for large quantity. And you never get the inside information what the ceiling of their payment, ceiling of the price they are willing to pay. So how to know that? They just go to China and bribe some people in that alliance in Chinese steel business, try to get some inside information about the maximum price or price ceiling China counterpart that wants to pay, and eventually it was found, and people get into that business, got sentenced to jail because that's bribery, that's corruption. GSK, they also do some illegal business. I know they are in China, they are pharmaceutical companies. So they bribe buyers in the medication business. What they do is normally pharmaceutical companies, you do detailing to doctors. And the doctors, if they think the medicine is good, they'll prescribe to they'll put them into his prescription and to their patients. So how can you boost the adoption for the doctors? They bribe them indirectly. For example, they sponsor their international trip. Not for business, just a personal trip, luxury trip to Europe, to other countries. And it's this kind of indirect bribery. And that was found by Chinese government. They do this because they want to promote their medicine, and they want to boost their sales. And that's a kind of indirect bribery. They do that in China. Walmart do that in Mexico. I know a lot of businesses are doing this all over the world. That's illegal. Okay, be aware of that, and you might be caught and get punished by doing this. Not only by the host country, the target country authorities, but also you might get into trouble in your home country in the States. Lastly, the regulatory environments. As a company, you can play different roles. You can adapt yourself to the legal environment, but at the same time, you can be actively play the role to change the legal environment. You can, like in US, companies can do lobbying. So you can change the regulations that rule specific business practices, right? So in European Union, there are 15,000 lobbyists representing these companies. Of course, I would believe these companies are big, and the non-profit organizations as well. So this is a situation. In Europe, there are some lobbying organizations or entities. In US, there are some. But to be frank, as a business, if you want to get into another country, don't think if you are not that kind of big, if you are not, you haven't been there for quite a long time, I don't think you will be in a position that you are going to lobby the government to change their regulations, right? So this is a trend, this is a situation, you have to be aware of that, but not necessarily you can do that. I think that's all for chapter 5, and thank you for watching. Thank you for your interest in these topics. Bye-bye.